'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Might be coming down for sure.
Now, if we have agreement, intent, consideration, then we've got a simple apparent contract and it looks like we've got ourselves a legally enforceable deal. But that's not quite the case. We have to also ensure that that deal is enforceable. So there are a number of things that might make a contract invalid, even though we've got that agreement, intent, consideration. So we need to go through those three building blocks, then make sure that we don't have something wrong with that process. And that's what enforceability is about and what we're going to do now. So we've got agreement, intent, consideration, which gives us that simple apparent contract. Now we need to make sure that the contract is not invalid. So we're going to look at the capacity of the parties, that consent is genuine, and we'll just touch on the legality of the objects. So a contract won't be enforceable if it's lacking any of these elements. So obviously legality. You can't sue your drug dealer when they don't supply good stuff, okay, because drugs are illegal, so therefore the contract matter isn't illegal. So again, that hopefully is a pretty clear area. You can't have a contract about an area that's not legal. An area that we'll come to in a little bit more detail is capacity, particularly this issue of minors. So that means people under 18, not people who dig stuff up out of the ground. Okay, so what happens if you're under 18? Can you enter a contract? The main area we're going to concentrate on is consent. Okay, did you truly agree? Did you really agree to the contract? And there's a number of situations that we're going to concentrate on: duress, undue influence, and unconscionability, three core ones. We're not going to deal with mistake. I mean, yes, it's part of consent, but it's not really used much anymore, and it's a very difficult technical area that is very not applied much. So we're not going to spend any time on mistake. Just be aware that it's there. The key thing to know about mistake is a mistake will very, very rarely make a contract invalid. Very rarely. So that's one of the reasons that we don't touch on it. Make sure you don't make mistakes is the key message. So as I said, we're going to concentrate mainly in this particular area of enforceability around consent, because that's going to be the area in business that you're more likely to have a problem. So what does that actually mean? Well, it means maybe the contract is invalid because you were bullied into it, or you manipulate, or they can get out because you manipulated them, or you lied to them, etc. So under certain conditions, there is no enforceability in the contract. It's invalid because they really didn't agree to it. There's something else going on that meant they didn't use their free will to agree. We're going to concentrate on undue influence, unconscionability, and also duress. So our first case, Barton and Armstrong, is a fairly clear case. What happened was Armstrong threatened to kill Barton if he didn't enter the contract. So Barton actually entered the contract. So B, as a result of this, enters the contract. But actually, the court held it didn't matter whether this was the reason. So there was some argument as to whether Barton would have entered the contract with or without the threat to kill Barton. Let's make sure that's a threat. That they might have entered it. The court said that doesn't matter. The mere fact that there was a threat of duress meant that the contract was unenforceable by Armstrong, okay? Because Armstrong had done the wrong thing. So that's an example of duress. In Johnson and Buttress was an older person, and back in the day in 36, it was quite old. He was 67, illiterate, not too intelligent, right? And as he got older, he started to rely on the advice of a distant relative of his deceased wife, Mary Johnson, and he transferred property, a house, to Johnson. So his son became aware of this, and when Buttress died, he challenged the contract that transferred the property to Johnson. Now, evidence was given in the case that Buttress relied on the advice of people around him, particularly Johnson. And in this case, Johnson had undue influence. Right? For instance, Buttress never got advice about the contract. So because of this undue influence, the contract was unenforceable by Johnson. So what we need to take out of this particular case is the relationship that existed between Johnson and Buttress. But Buttress had started to rely on Johnson. So there was a relationship, and then after that, the contract was entered into. Okay, it was unenforceable because of the undue influence due to that relationship. Our final case is one of the most famous in commercial law in Australia, CBA and Amadio, and it deals with unconscionability. So what we had was some elderly, I believe they were Italian immigrants who didn't know much English, not much English. They don't know no knowledge of business. Okay, and what happens is a bank, or a bank manager, gets them to give a guarantee for their son's business. So the son is running a business, has a loan. The elderly couple own a house. They get a mortgage on the house to guarantee the loan. That means if the son can't pay, they have to pay it back. As you can imagine, the son's business failed and the bank called in the loan. They argued that they had no idea that they were signing like this guarantee for the certain amount of money in a certain amount of time. And the courts agreed with them and held that they were actually at a special disadvantage, right? Because they were elderly, because they didn't speak much English and didn't know much about knowledge. They didn't really understand what they were doing and that they were guaranteeing the business of the son, etc. And so the bank took advantage knowing that, because they'd met them and they knew all of these factors and understood, because they'd seen some interactions with the son, that the parents might not have fully understood what they were doing, and they took advantage of it. In that sense, the bank acted unconscionably. So unconscionability. This is a key one in business. If you know someone has a special weakness or disadvantage and you take advantage of that in the negotiation, the contract is probably unenforceable due to unconscionability. So there are three cases that go through, duress, undue influence, and unconscionability. In the next video, I just want to unpack that a little bit more, because some of the exact rules around those tests are a little more complicated than what the case may seem. It helps you work out whether there truly is duress or undue influence or unconscionability. More of that in the next video.